I'm joined by Harry Litman of the Talking Feds YouTube channel, Talking Fed podcast, and Talking Fed Substack. Harry, I want to talk about the most productive use of the pro-democracy time, the lawyers, constitutional scholars in pushing back right now against Donald Trump's agenda. And I want to get your views and perspectives. You're a former top federal prosecutor, law professor, scholar. I think it's critical that we know what you think is the most productive use of time right now. I mean, there's been a lot of talk right now about the 14th Amendment, Section 3 disqualification issues, which unfortunately I thought was resolved wrongly, but resolved by the Supreme Court back in March of 2024, where the Supreme Court's majority opinion ruled that federal legislation from Congress was necessary for there to be disqualification. All 9 of the justices ruled in a 9-0 per curiam opinion that Colorado was wrong for disqualifying Donald Trump when I thought Colorado was right. But in any event, all 9 said Colorado was wrong. But then there was a divide between 5 justices and 4 justices. And the 5 justices in the majority said, actually, the 14th Amendment, Section 5 requires legislation. And lots of people were saying, whoa, but Section 3 talks about 2/3 of Congress needing to remove the disability. Doesn't this make clear that the 14th Amendment, Section 3 is actually self-executing? The disability has to be removed. So the Supreme Court decision doesn't make any sense. And to that, I've said, the 3 to 4 justices who wrote the other opinion agree with you. They say that it was wrong that the Supreme Court shut the door to other forms of challenges against this whole new scheme of federal legislation being required for disqualification. That wasn't even the issue presented to the Supreme Court, but nonetheless, that's what the Supreme Court ruled. So Harry, I mean, there was this article in The Hill that says Congress has the power to block Trump from taking office, but lawmakers must act now. And when you look through this article, it basically says, look, Democrats should pretty much ignore what the Supreme Court did, view what the Supreme Court ruled was just dicta, bring up the objection, and then it recognizes, though, that it would still require MAGA Mike Johnson and the Republicans to go along with the disqualification, or else it would fail. And then they say once it fails, then go and petition back to the Supreme Court that just ruled against you, but you should go and do that anyway. You know, and my perspective is that I'd be very concerned about that, because you're going to hand Donald Trump a win on January 6th right away. He's going to declare victory. You're going to hand him another win at the Supreme Court. You know, these decisions that have been overturned by the Supreme Court, where they've overturned their own precedent, that happens over decades, not over a 9-month to a year period. So I've only been saying, look, folks, this is what the ruling is. I'm worried that that strategy backfires big time, when I think that, unfortunately, there's, you know, that's not a path, but there's other productive ways that we can go about it. So I want to hear from you, Harry. What's your perspective and thought on this whole issue?
Okay, so man, oh man, Ben, what a tangled web we weave on this one. Because, you know, you're right. The words seem really clear. Nobody ever really looked at them. They were passed in the wake of the Civil War to try to keep the Southern rebels from then coming back in to the Congress. They had that effect for a while, and then Congress declared amnesty. But in black and white, it just says, if you have sworn an oath to the Constitution and proceeded to commit or aid or abet insurrection on the United States, you're not eligible anymore to hold high federal office. Seems to fit Trump and nobody but him since the Civil War like a glove, right? And it's just sitting there like a fact, the same as other parts of the 14th Amendment. No state shall deny due process or equal protection. Nobody says that Congress has to take a vote to make that happen. That's just a fact. But you have this riddle. A lot of us saw it. You saw it when it came to the Supreme Court. back in the Colorado case that even though that's what it says, how exactly you could authoritatively trigger it was a head scratcher. Would it be, for example, you had, a trial court in Colorado say, seems to me he committed insurrection. There are factual issues, right, to have to go over. Would that do it? What about, if somebody protests the eligibility of a candidate because they're not 35? It's really just a citizen who turns it in to maybe the Secretary of State. Would that do it? Obviously, the Supreme Court got really nervous at the notion that Colorado could decide this for the country, and yet they really they were wrestling with it in a way that was not very satisfying. You say about Section 5, that's an important part of the 14th Amendment, but that says specifically Congress shall enact legislation consistent with these provisions, and 3 doesn't say that. That said, there were candidates for what would be the most authoritative, maybe a conviction by a court, maybe a high state effort, maybe Congress. And as you say, the court pretty much said they were, it's a little bit dicta, and it was more kind of almost philosophical in this part of the opinion. But they're saying, here's what you need. You do need Congress. And I do think Congress now probably would do it. But I agree with you on the bottom line, because ain't no way that this Congress will vote to disqualify Trump. If it were even going to be a close call, you could imagine it being a worthwhile effort, but I think in the event, what it will be is exactly as you say, another win for Trump and a apparent overreach by his opponents. So it's just not a fruitful use of resources. There is one other thing that could have happened that was made clear in the Supreme Court opinion. Jack Smith could have charged Trump with insurrection, and that statute provides, so it's the equivalent of Congress's vote, that a disqualification from thereafter holding office. But that too then would have taken the overall judgment of Congress, or at least incorporated it in a jury conviction. So it leaves a puzzle for constitutional scholars. How exactly do we effectuate the clear command of the 14th Amendment? I've talked about this with a lot of people. I had a long one-on-one with Judge Michael Ludick, who called the opinion of the Supreme Court an abomination, except he said it even, longer. And it's an unanswered question, but the practical question for now, which is, can you try to use this as what would otherwise be a silver bullet against Trump's ascent to the presidency? It strikes me as a non-starter and something that would just play into his hands. So there, I agree with you.
I see the comments from time to time, and they go, that's not what the Section 14, that's not what the 14th Amendment Section 3 says. It says he's already disqualified. Mm-hmm. It says that you have to remove the disability, to which I say to those people, I agree with you. I read it. I understand what it says. All I'm trying to say, and I think what you're saying and others are saying, is why Judge Luttig said it was an abomination is because you do have pretty clear language in the 14th Amendment, Section 3. Perhaps the drafters of that didn't anticipate a situation like this. They were dealing with the post-Civil War situation and trying to use this as kind of a bulwark against, what was happening in the immediate term. But the Supreme Court kind of ignored that language. They went to Section 5 and used Section 5 in a way that contradicts Section 3. But that creates this kind of problem now, which is, if you were a lawyer and you went and filed a lawsuit under the 14th Amendment, Section 3, and just think about all your favorite aggressive lawyers out there who have been on the front lines of fighting. I mean, Harry, the reality is that at best, you would be laughed out of court. At worst, you'd potentially lose your legal license for going against the actual Supreme Court precedent and bring this. You'd probably get Rule 11 sanctions filed against you, and you would end up owing hundreds of thousands of dollars or perhaps more in legal fees. And, you may say, well, that's a righteous fight. You got to fight it, but you're going to lose. You're going to lose that battle. And it pains me to say that. So then you go to the Congress, and what does Congress do here? I mean, as I read the majority opinion, and I think it's absolutely wrong, but Congress could create a framework whereby there would be a mini trial or an adjudication of the issue. It goes through this process. There's some judicial oversight, the same way Congress creates agencies. You create a mini process for how to deal with it, and then it's resolved. But Harry, this Congress couldn't pass a continuing resolution to fund the government. So it's there, and MAGA Mike Johnson is going to be an ally in disqualifying Trump. Come on, that's not. I don't think
so. Now, let me say, by the way, in the past, you didn't have any of this stuff. After the Civil War, lots of former rebels were disqualified, and a little known footnote to 14 Amendment Section 3. After World War I, there was a socialist sent to Congress from Wisconsin, and Congress said no, calling him a traitor and disloyal, and used this provision. And they sent him back. The voters then sent him back again, and Congress sent him back again. Then they voted him in a new time, and it was settled. But that's how it always had worked. Congress just expressed its view. That didn't mean, of course, it was the only way it could happen. This is in some ways as clear as somebody being 34 or not being born in this country. And that it wouldn't take the whole apparatus that you're saying. But this is different. And I'll just say, frustrating though it may be, constitutional lawyers are familiar with the idea that there can be a clear violation and yet nothing to be done about it. And for whatever reason, that's the posture we're in. And so you're right, man, oh man, rather than tilting at windmills, how about just continuing to call out and loud the lies, continuing to fight back against every inroad on democratic rule, sound the alarm as best you can. At least that creates some kind of, hopefully, momentum, awareness of what's going on for the next time that people can express their views.
And I hear sometimes people very cynically say, okay, you're just posting about these things and you're just making videos and what's that going to do? And I always say this, I go, do you think that Fox is successful at hitting a demographic? Do you think that they're persuasive at change, of preaching to their choir? And do you think they're effective in getting people to rally around their views, which is mostly disinformation? And all people go,
I just want to underscore that they do it, and it persuades people of lies. So yes, Ben, I think you are living proof that you can convince, at least push back with the truth.
Exactly what you're building at the Talking Feds YouTube, the Talking Feds Substack, and the Talking Feds podcast. And that's what we're trying to build at this network. Harry, thank you.
Thanks, Ben.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.